only yesterday we've heard all the hue and cry regarding the increasing energy prices, which we know will have a knock-on effect on so many other things, which will require us to manage costs, which will require us to manage our employees and our situations in a different way than we have done. So all that said, what is required really is a change for all of us as managers in the ethos, in the approach that we bring to management, in the approach that we bring to motivating our employees and getting them to do the very best. And we encourage you to look at this, look at all of your activities from the perspective of partnership, because at the end of the day, just as the employee needs the business also needs the employee. And it takes a lot of time, believe me, in managing workplace issues, workplace problems. And so our wish for you is that you will enhance your practice and to improve, do all that you can to improve cooperation within your workplace. And one of the best ways that we at the Labor Department can think of is for you to avoid, as far as is possible, issues that lead to dispute and to contention, to look more in terms of partnership, know your rights, know your responsibilities, share with your employees, your supervisors, your managers, share responsibility, because we oftentimes are sidetracked in terms of what our rights are. And yes, the law does provide rights, but it does provide an awesome responsibility for each of us to manage the workplace in such a way that the business may continue, that the business may be successful, and that ultimately we all can benefit from the economic growth that results when businesses are successful. So do enjoy. We will hear very shortly from Mr. Lawrence Mears, one of our labor officers here at the department. And his session today is, it takes into account the contract of employment, the factors to consider. And this is a very important part of our work and a very important part of your work as well. So we hope that you will get the utmost from it. After Mr. Mears' session has ended, we will then lead you into a discussion in relation to the appropriate disciplinary procedures that we wish you to follow. And I must admit that in doing that, we have a selfish interest, because if you follow the procedures properly, we anticipate that we will have less claims to address, less issues to deal with, and allow us then to do other types of work that is also required in terms of modernizing the employment relations framework. When you come back to us on Thursday, those of you who join us on Thursday, we'll be discussing the Holidays with Pay Act, as well as other issues in relation to employment leave. And we certainly wish for persons to participate actively in those sessions. They represent, in large measure, a significant portion of our work there each and every day. And then next week, we'll look then at two of the more modern, two of the most recent enactments, and those which create a bit of a challenge for many managers, those being the Employment Sexual Harassment Act and the Employment Prevention of Discrimination Act. So we look at those with you on Tuesday next week. So again, let me issue to you a very warm welcome, and to repeat that we are really happy that you have joined us as we carry out our mandate in relation to labor legislation and best practice in Barbados. And with those few words, I invite our presenter for today, Labor Officer Lawrence Mears, to address you. Over to you, Mr. Mears.
Thank you, Mr. Sobers, for those opening remarks. Let me say good morning to the participants in this webinar. Like Mr. Sobers would have said, I'm Lawrence Mears, and I am attached to the Industrial Relations section of the department. And my topic in this segment of the program will be the first schedule and the employment statement of particulars. And I will be sharing the screen with you so that you can both follow. All right, so the Labor Department presents the first schedule and statement of employment particulars. This section will look at the contract of employment and the factors to be considered when the contract of employment is being contemplated, and what is to be included in the statement of employment particulars. In this presentation, I am being accompanied by two labor officers, Ms. Gail Grant and Ms. Heather Holder, who will be acting in the capacity of facilitators to respond to your questions and queries. The first schedule, the first schedule, we will look at the elements that gives a person a profile as an employee. And that's the first slide you're seeing will state, and not to make new provisions for the rights of employed persons and for related matters. And when we talk about related matters, the employment statement of particulars can be seen or viewed as a related matter. So the first schedule is important since it gives a profile of the elements that makes a person an employee or working under a contract of service rather than under the dubious terms such as a self-employed contractor or simply a contractor that the Labor Department is seeing creeping into our industrial relations. Very often, persons would either call the Labor Department to query about their employment status since they would have been employed thought that they were employed under a contract of services, only to be told that they are self-employed persons. And just imagine this scenario that you would have seen a job advertised for either a mechanic or a carpenter, probably a mason. You applied, had the interview, and was given the job. You were told what the salary or wages would be. And then you are told that you are responsible for your own NIS deductions. When you query further why you are responsible for your own NIS deductions, you are told that you are a subcontractor or a self-employed person. The first schedule of the ERA will set the tone as to what makes a person an employee. So where we see in this first slide, the term express and implied. Express and implied terms form the basis of every contract of employment, are essentially the rights and duties of both the employer and the employees in the contract of employment. Some rights and duties are explicit, i.e. express, while others are silent, but underline the function of the contract. So an implied term would be honesty, trustworthiness, paying attention to detail. A contract of employment would not state these terms. However, an employee is expected to behave in an ethical manner, to be truthful, and to be diligent. Those would be considered the implied terms of the contract. So we will now look at the first schedule. But before we go dive into the first schedule, Just let me say that a contract can be either in a written form or oral. However, it's always better to have a written contract for the reason it's more formal and everyone would be on the same page. Nevertheless, an oral contract functions on the basis of the work that the employee does over a period of time. And persons that would come to mind would be domestics in the home that work in private homes, as well as gardeners. Most of these persons do not function under a written contract of employment. As it relates to oral contracts, very often workers come to the Labor Department and inform that they were never given a contract of employment. This is always incorrect, for the reason that when it relates to someone in employment, the moment an offer of work is made and the offer is accepted, a contract has been formed. So just let me make it clear that even though you might be operating without a contract, from the time you take up the job, a contract has been formed under the law. So the first set of slides, we gave the schedules, and it will give the elements that make a person an employee and clearly establish the profile that determines whether a contract of employment exists. So you are to give personal and exclusive service. And this opening remark is quite clear, since it speaks to giving clear and exclusive service, meaning that it would the employees to avoid any conflict of interest for the reason that a conflict of interest will most likely benefit the worker at the expense of the company. And companies would not want that. So hence you have to give personal and exclusive service. The employee is expected to channel all his energies into performing the tasks for that particular employer on the particular time that he's to work. The employer gives instructions to the employee. The employer will give instructions on how the work is to be performed. In some companies, this is done through worker orientation and training programs. The work is also one of a continuous nature, and it creates an economic dependence on the employer for the reason that you're remunerated either on a weekly, fortnightly, or monthly basis. Therefore, there is no financial risk on the part of the employee when he is working, because he is not an investor, nor is he a director in that company. The only form of investing that he does is to invest his labor within the company. The work is performed within fixed hours. So the work might be performed during an 8-hour day, starting probably from 9 to 5, 8 to 5 at the lunch hour, or on a shift basis, as you would see probably in places that have nurses, security officers, and so on. Moreover, the employer specifies the place or places or where to report for work. So let's say, for example, you are employed by either Massey or Shafat, and they would have had quite a number of branches throughout the island. So the employment can be in Whole Town, whereas the head office might be in Bridgetown. So the employer will specify the place that you are working at. The worker is subject to the workplace policy and rules. Employees are bound through the company's code of conduct to act in the interest of the employer, and any departure from the policies and rules as stated in the policy handbook can lead to disciplinary action being taken against them. So companies would, on gaining employment within the company, you will be given a contract of employment, statement of particulars, and the employee handbook that spells out the rules and regulations of the company. The worker is in receipt of remuneration either on a weekly, fortnightly, or monthly basis. In addition, the worker makes no investment or only nominal investment in tools and equipment, for example, carpenters with a hammer and a saw. So as I said, the worker would be in, would get a remuneration that will form part of the elements that would make you a contract worker, an employee. Moreover, you will have entitlements such as holiday with pay, notice, and severance pay wherever applicable. Now, if you work long enough within a company, let's say the threshold is 104 weeks and the company closes, you would be entitled to severance pay because you would have been made redundant, and severance pay is only paid when a person is made redundant. So this is one of the entitlements for a person who is employed under a contract of employment. And I will reiterate that the person who is employed under a contract of employment makes very, very, very nominal investments. And in case of a carpenter, he might bring a hammer or a saw, as well as his labor. In the case of a mechanic, he might just bring a couple of spanners and so on, but he will be considered an employee. We will now go to the statement of employment particulars. And it states here that the employer shall forthwith at the start of the relationship issue to the employee a statement of employment particulars. After any changes in the contract of employment, the employer shall give the employee a written statement of particulars of the changes not later than 30 days after the change was made. And this is important since the statement of particulars mirrors what the contract says. However, the statement of particulars can be changed by the employer to include changes in the business environment. But if there is to be a change in the contract of employment, it must be done. Both persons must sit down and work out the contract. So employer cannot willy-nilly change a contract of employment unless he wants to be charged with probably unfair dismissal through constructive dismissal. So the statement shall contain the employee's name and address of the employer. And these are important issues or elements of the statement of particulars, because labor officers will often tell you that persons make representation to the labor department and they are not familiar with the name of the employer. They might have the address as in the business name, but when it comes to the name of the employer, they do not know who's the name of the employer. Some of them cannot remember the start date of the employment. I would have had a gentleman that would have called the labor department about 2 weeks ago. He could not remember the start date of his employment, and that would have been about 2 years ago. He would have started about 2 years ago, but he could not remember the start date of the employment. So it's important that employers give a start date of employment, also the probationary period, whether it's 3 months and if it will be extended from 3 months to 6 months. Those are things that should be included in the statement of particulars. The job title should also go into the statement of particulars, as well as a description of the work. And a job description is another element of contract of employment, in that it states quite clearly what the employee is expected to do. So it's important that within the statement of particulars that you give a description of the work that is to be done. In addition, the rate and the method of calculating pay is important, since persons should know upfront what their hourly rates are or their monthly remuneration is. Again, the employment statement of particulars will state the intervals at which wages will be paid, whether it will be weekly, fortnightly, or on a monthly basis. It will give the normal working hours, whether it is from 8 to 4 or whether there's a shift system. It would also give the notice required on either side of the table. And this is important. If an employee is terminated without the employer giving him adequate notice, as is set out in the Employment Rights Act, Section 22, that person can make representation, that employee can make representation to the Chief Labor Officer. And the Chief Labor Officer will look into the matter, and the company will have to pay the notice pay. It is also important, although there are no penalties attached, that employees give adequate notice also to the employers when they are thinking about resigning from the company. What we would have seen here at the Labor Department is that workers will give forthwith resignation and expect that that will suffice. That is not good. It does nothing for the employment relationship. And it is a matter of fact, slamming the door in the face of the employer. Therefore, we would ask employees, since it is stated at Section 4 of the same, subsection 4 of the Section 22, that employees are also expected to give adequate notice when they are terminating their services to an employer. Now, if there's a fixed term contract, then the fixed term contract, the contract will state explicitly when the employment will begin and give the date that it will end. Some fixed term contracts are done when there are special projects being carried out by the company, and if you give an expected end date, sometimes it might go over that end date. So let's say, for example, you're employed on a fixed term contract for 1 year. A month before that year is ended, is to be completed, and the employer sees that the project will end on time, he's expected to give you adequate notice, even though it is written in the contract that the work will end on the particular date. When that job has finished on the particular date, then you, the employee, would be the beneficiary of holidays with pay, because during that time of employment, you would have been accruing vacation pay. So if the contract is one of a temporary nature, then it will be stated on the contract that the contract is temporary, and that too will give a start date and an end date. We would have looked at the places of work where we would have spoken of the contract of employment. And information should also be given about any collective agreements within the company. Some companies have collective agreements with the union, various unions, and that information should be shared with the new or prospective employee at the beginning of the internment with the company. Then, as an employee, you are entitled to annual holiday. And the annual holiday will be prorated, and that would fall, the law says, within the first year of your employment. However, if for some or no reason you are terminated before a year is up, and you would have had 48 consecutive days or 3 months of employment with the company, then you are entitled to average holiday pay. Your entitlement to sick leave and injury pay. And because you're paying NIS, NIS deductions are being made on your behalf by the company, and you become ill or have an injury on the job, then you can turn to the NIS for sickness benefits and so on. The company should also share in the statement of employment particulars any information as it relates to any health schemes. And we know that in some companies, the health scheme is tied to a cutoff date for employment, and that should be stated within the contract of employment as well as the statement of particulars. So even though there is no official, there is a pensionable age, there is no retirement age, but companies that have a health scheme will tie their retirement age to that health scheme. Information in relation to disciplinary rules. This should be stated in the employment statement of particulars, and it will be stated in the employee's rule book, where sanctions will be given for certain breaches of the contract, and it might lead to warnings, both written or oral, suspensions, or even termination. And the statement of employment particulars should also identify whom persons can make claims of dissatisfaction or grievances. The company would have a hierarchy of, might have a hierarchy of persons that you can turn to, probably in their HR department, to make any dissatisfaction claims or grievance claims. And it should also list the steps to be taken where there are complaints or grievances. Any changes to the statement should be done in writing and should be given to the employee within 30 days. Now, if an employee has not been given his statement of particulars, these are the things that he can do. Or if he isn't given the itemized pay statement, or if the statement does not comply with what is required, the employee can make representation to the Chief Labor Officer. And the complaint would be looked at and sent to the tribunal. So either the employer or the employee can make a complaint to the tribunal for its determination if, after a statement is given, a question arises as to what particulars ought to have been included or referred to in the statement. And if a statement has been given and there are changes to be made, the company can go ahead and make the changes, but it must be done in writing and given to the employee not less than 30 days after the changes would have been made. We have now come to the end of the presentation, and I will encourage participants to ask questions. We have 2 facilitators on hand to answer your questions and your queries. They are Ms. Gail Grant, Labor Officer, as well as Heather Holder, Labor Officer. Thanks for your participation in this webinar, and I'm looking forward to hearing the questions. Are there any questions that persons would like to ask me directly? You can go ahead and ask those questions now.
Good morning. Can you hear me?
Yes, I'm hearing you.
Okay. Thank you for that excellent presentation, Dale Hunt, Massey Stores. Just a question. We know that if an employer wants to, end the contract with the employee, that company has certain things that they must take care of in terms of making sure the employee get noticed and so on, and anything dealing with redundancy and so on. But if the employee themselves wants to leave the company and does so forthwith without giving any notice or anything of the sort, there are really no much repercussions there. So just want to get a little information based on your experience around that.
Okay, that is a very good question, and it is one that we would have had two persons last week resigning forthwith from a company, and the company would have indicated that they would exercise the option not to pay them. They were monthly paid persons, and within the contract, they were expected to give a month's notice. However, in the opening remarks by the Deputy Chief Labor Officer, Mr. Wayne Sobers, he would have alluded to the rights conferred on employees by the legislation, as well as their obligations. And at Section 22 of the Employment Rights Act that deals with the notice pay, at subsection 4, it gives an obligation to the employee to be responsible in giving adequate notice to the employer. However, there is no punitive actions that can be taken. There are no penalties. Therefore, employees might have to seek recourse through the law court. They can't come to the Labor Department to have their case adjudicated. However, if on the flip side, if the employer does not give adequate notice, then the person can come to the Chief Labor Officer and make a complaint. So even though the law requires persons to be responsible when they're exiting the company, there are no penalties attached to their leaving without adequate notice. I hope that answers your question.
Yes, it does. One of the things I would add there as well is that, it's always good that if you're leaving an employer, that you always leave on a good note as well, because you don't know where the future takes you. And also it kind of sends a signal as well, maybe to your future employers of the kind of person that you may be. So, it may be good to dot your T's and cross your I's in terms of what is required of you as an employee.
You're so right, because I call it slamming the door. You might need some form of reference from that employer in the future. He does not have to write anything pleasant on your towards your future employment. Okay.
Thank you.
Okay. You're welcome. Is there anyone else?
Good morning.
Good morning.
Yeah, I heard you speak about temporary employees. Like, if you employ someone for a year and they're leaving, you give them vacation pay. My question is, if I employ someone for about 4 months, 4 to 6 months, when they're leaving, do I have to pay them what we call 352 parts, or that's not necessary?
Yeah, that is necessary, since the person would have accrued vacation over the 6 months. So they would have been accruing vacation over that time period, and they're entitled under the law what you call 352nd parts. We call
Yeah.
it prorated vacation pay.
Oh, okay.
But you will use the 352nd method to calculate the vacation pay.
Okay. All right. Thank you.
You're welcome.
Good morning.
Good morning, sir.
I would like to find out if you have an employee that's come to age of 67, so pensionable age, can the company, or should I say, can the company retire him, or does he have to choose to retire at that age?
Okay, first up, there's no retirement age in Barbados. There's a pensionable age.
Right.
And if you try to force the guy out of the company, he can sue you for unfair dismissal.
Mm-hmm. So is it up to him to choose when he wants to end his employment?
There might be other factors that might help you, but based purely on age, it might be this. He might see it as discrimination because of his age. And then he might decide to sue the company for discrimination as well as unfair dismissal.
Right. Okay. So how does a company determine if someone is physically able to continue doing their task? Because obviously with age comes possible reduction based on the position the employee may hold. More so in a labor side of things. How do you come to that conclusion of when the?
I think if you have if you have measurable targets and so on that the person is not meeting, you might be able to talk to him,
right,
and give him a chance to improve in those areas. And then if there's no improvement, then you might decide to cite Section 29 of the Employment Rights Act. But
right,
it's best that when persons are forming a company, most major companies will put retirement age into their contract, and in most cases it's tied to the insurance scheme.
Right. Okay.
Okay.
All right. No problem. Thank you.
Oh, no, you're welcome. I see that hand raised there. Can you go ahead and pose your question, please?
Yes. Good morning.
Good morning.
I'm calling in reference to, I had asked a question in the questions and answers regarding set scheduled sick days. What does the law say regarding set scheduled sick days? And if in your job description, it says you must not exceed 6 uncertified sick leave days per calendar year, does that imply that you should be paid for those 6 scheduled sick days?
All right. There's no provision in the labor laws for sick days, uncertified sick days. That is a common law practice or customer practice that some companies would adopt. So a company would indicate in your contract of employment, statement of particulars, that you would have 6 uncertified days. They would also indicate that they are not to be taken all at once, and they will be spread out over a period of time. So if you're sick, let's say the company has 6 uncertified days, sick days. And during the course of the year, you would have taken 7. You would be paid for 6, but the 7th day, then the company would deduct that from your pay.
Okay, but once it says that in the statement of particulars, you really should be paid for it.
Yes, I thought I stated most companies will state it in their contract as well as the statement of particulars. And they would honor it. In most cases, it is honored. It's only if it's abused, then it might not be honored. But when persons are approaching the 6 days, let's say they are at number 4, some companies will write you and let you know, well, look, you only have 2 more days left that you can use as uncertified sick days.
Okay, understood. you.
Okay. Kelly Watts.
Hi, good
Hi.
morning.
Good morning.
Hi, I'd like to ask a question. I want to go back to the gentleman who spoke earlier about that retirement age, because that is very interesting to me, and I want to make sure that I'm clear in terms of what you said. So you noted that there is no retirement age in Barbados, but there is a pensionable age, which we would, if I'm not mistaken, term at the age of 65. So
67
if,
now.
well, sorry, right, I know it's 67 now, but ideally, we always look at 65, but thanks for that. My question to you is, if we have an employee who is approaching, so, all right, so let's say our employee is 65 or 64, let me use 64. And we ask them, we say to them, look, you're approaching early retirement, you need to, or you're approaching retirement, sorry, and you need to write us and let us know that you want to retire. Is that illegal or incorrect?
Just hold a second. You're approaching pensionable age, not retirement age.
Oh dear, I have to keep that in my head and not use the word retirement anymore. So that's going to be a switch for me. So you're approaching pensionable age, and you need to write us now to say to us that you will be retiring from the organization once you reach age 67.
Why would the person have to write you to say that?
That is a practice that I am aware of. So, because you just okay, because of what you just said, that really sent off a red flag for me. So I just wanted to ensure that I'm understanding you correctly. So ideally, someone could work till whenever they decide, 70, 72. Is that that's what I'm understanding you to say?
I'm sure that you're familiar with the Barbadian landscape. Most persons are longing to reach age 67, their pensionable age.
Yes.
So that they can go home and play with their grandchildren.
You
know, so I don't find it to be a real big problem in Barbados. I remember some years ago, a gentleman came into the Labor Department, and he said that he was forced out of the company. I asked him to bring it. He was 72 years of age. And when he brought the contract explicitly said that the retirement age of the company is 72. So the company was within their right then to ask him to retire.
Okay.
However, he was such a good employee that when persons went on vacation, he would come in on short-term contracts or sick leave and work for those persons.
Okay. Okay.
Okay.
I think I have my answer, because if it's captured in our contracts, then we're okay. All right, no problem. Thank you very much.
Is there anyone else with questions? Ms. Boche, go ahead.
My question again, when an employee reaches pensionable age and they're leaving your employee, do you have to give them severance or anything like that?
No. Severance would only be paid if the company is making that person redundant.
Okay, so you have no financial obligations toward that person?
If you want to give them an ex-gratia payment, it's up to the company, rewarding them for the good services and so on. But there are no legal requirements under the law, under the labor laws.
Thank you.
You're welcome. Anyone else? Any other questions? Is there another? Is there anyone with other questions? Ashley Pitt. Go ahead and pose your question, sir. Sorry, ma'am.
It's okay. Good morning.
Good morning.
I wanted to ask a question.
My apologies.
It's okay. It's okay. I know Ashley is a common gentleman name, but it's all right.
Okay.
I wanted to ask a question about, it wasn't have to do anything about being retired or anything. It's actually two questions. One, you have mentioned previously about the probation. Is it, I know some companies do 3 months and I know some companies do 6. What if I was brought on to do, to work on a contract and they say that the probation was 3 months, and after my 3 months is over, they say, oh, well, I have to go another 3 months for probation. Is that right, or can I do something about that?
That is okay under the law. Persons would try, or probably within the first 3 months of your probation, you were not living up to standards, and the company would extend the probationary period to see if you'll be a right fix for the company. So there's anything wrong with having an extension to the probation period, and it will be written within the contract of employment or within the statement of particulars. So some companies will say, for example, that the probationary period is 3 months. However, if we reserve the right to extend it for another 3 months. So that will be written within the statement of particulars.
Oh, okay. My last question would be, within the probation time, should they be able to still take out NIS, or?
Oh yes, you're asking a very good question there. From the time you start to work, NIS should be taken from your wages, not after you finish the probationary period. And that is a common practice. That is a practice that is creeping into our industrial relations landscape in Barbados. That persons are saying that the start time is after the probationary period. However, the ERA is very explicit in that it states from the time a contract of employment is being contemplated, one, you should give the person a statement of employment particulars, and that starts the employment. It gives the employment date, which should start on that date. So if today is the 8th, you start on the 8th of March, 2022, and there's a probationary period of 3 months. At the end of your probationary period, you should have had 3 months of NIS contributions being paid in on your behalf.
And if it's not being paid?
You can go to the NIS department, and you can come to the chief labor officer, but preferably go to the NIS department. They're the ones responsible for the NIS contributions. They have field officers that will go to the employers and make sure that they're paying your NIS into the scheme.
Okay. Okay, thank you very much.
You're welcome. Any more questions? Ellsworth Young. Mr. Ellsworth Young. Go ahead and pose your question, sir.
Yeah, excellent presentation.
Thank you very much.
In your statement, you say that if the employer wants to change the particulars of the job, he has to, under section 15(1), write and inform the employee of the changes in the particulars. Does this suggest that the employer has the power to do that based on full consultation of the employee? Because as I understand it, Lawson, if the employer does that unilaterally, he can be held to be in breach. Am I correct?
Yes, but I don't think that employers would willy-nilly change a statement of particulars. There must be elements within the environment, the working environment that would necessitate a change in the employment statement of particulars. And for good employer-employee relations, I believe that he should consult with the worker while making these changes. And, just inform them, look, the employment landscape is changing. We have to adapt. And here are some of the changes that will be made to the employment statement of particulars.
Thank you.
Oh, you're welcome. Are there any other questions? Jennifer Braffett, and go ahead and pose the question. Ms. Braffett, go ahead and pose the question. And Hamilton Cutting, go ahead and pose the question, please.
Yes, hello, good morning.
Good morning to you.
Yes, thank you for the presentation. I wish to present a scenario to you to get your feedback on it. Suppose there's a situation where a person worked with an organization for a number of years, but during the COVID period, where we had all of those challenges, work was stopped at some point in time. They never received any severance, but they would still go into work from time to time, and do a few hours and so on and so forth. Now they're considering returning to the organization in a full-time capacity. What is supposed to happen, with this relationship between the employee and employer? Do they just pick back up from where they left off? Do the number of years continue? What really should happen? Because remember, when they were just working maybe a few hours and so on, they weren't paying any NIS either. So what should happen?
First of all, not paying NIS is breaking the law. That's the first thing. The work only stopped or ceased because of the COVID environment. So the person would still be an employee.
Okay.
There wasn't any formal severing of the relationship in like termination or anything like that. So the person is still an employee. The companies returning to the full workforce now, he would be expected or she would be expected to rejoin the workforce.
Okay, thank you.
Okay. Jenny Perkins.
Hi, pleasant good morning to all. I just have a quick question. Can a company change their company name and force staff to sign new contracts under the new name?
The change of name, does the type of work change with the change of the name?
No.
Okay, so then why should they be forced to sign a new contract?
I asking you, sir.
I'm asking the question now. If there is no change in the type of work that's being performed, it's only a change of company name. And I would assume that the change probably, did someone else buy off the company?
No.
Okay, well then the work will continue as normal.
Okay, thank you so much for your time.
Okay. Sherry Ann Smart. Go ahead and pose your question.
Hi,
Ms.
good
Murray,
morning. Can you?
okay, you have to unmute. Okay, go ahead.
Oh, you can hear. Oh, good
I'm
morning.
hearing you
Sorry,
now. I'm
sorry.
hearing you now. I'm hearing you now.
This is my first time using Zoom. Sorry.
Oh, that's
Okay, so
okay. We got to start sometime.
okay, thank you. I have a question. How long can an employer have you on a probation status?
I would think that I won't go more than 6 months. I personally wouldn't go more than 6 months. Because that would
Okay.
give the employee enough time to know whether or not you are right fix for the organization.
Oh, okay. And by law, how much time? Because
there's no stipulation on the law.
Oh, there's no. Oh, okay. And I had a question as well. You were speaking about notice before termination. I know that you're supposed to give notice if you're resigning, but in terms of if an employer is terminating your service, they usually terminate you on the same day at the end of shift. Is that something that's supposed to be done, or are you supposed to have notice before you're actually terminated?
The law requires that if a company is going to terminate the services of an employee or employees, they should give them adequate notice. Also, there is something called a 6 weeks consultation, that if a company knows that they're going through phases or a downturn in their economic situation, and they think that they might have to make persons redundant, they should, let's say, at least 10% of the workforce, and they should give consultation at least 6 weeks. However, if an employee comes and terminate your employee at the end of a shift, there might be a reason for that, in the sense that it might be known as a summary termination, and may have to be terminated for gross misconduct.
Okay.
Right.
Okay.
But under normal circumstances, a company should not terminate your employment like that.
Okay. So what if they do?
If they do, then you have recourse. You have recourse to the chief labor officer.
Okay. And is there a time frame?
3 months. And let me add though that the qualification bar is at 1 year. So if you're employed with a particular employer, for 1 year or more, and you were terminated like that, then you can seek recourse to the chief labor officer.
Oh, okay. And if it was less than 1 year, you can't?
Well, if it's less than 1 year, you can't make a claim for unfair termination. And that all throughout all the jurisdictions that have employment right, have an Employment Right Act. And as a matter of fact, I understand that Britain is even thinking about moving the time to 2 years.
Oh, Lord. Oh. Wow. Oh, okay. Okay, that's all the questions I have right now. Thank you very much.
Okay, those are good questions.
Thank you. Bye-bye.
Okay, you're welcome.
Hello again. I have another question. What really should an employee do? They've started work. Let's say they're working for about a month or two, and they're being paid less than $8.50 an hour. And they're told, well, they're new to the organization and so on. So that's why they're not being paid, the minimum wage.
But they should make representation right away to the chief labor officer. They can come and make a complaint to the chief labor officer, and we will investigate the case.
But is it that perhaps that employers are not made aware of the responsibilities. They're not sure. I mean, and especially in the case of non-Barbadians, you know, is it that employees need to be better educated in terms of what needs to happen?
All right, let me first say that these forums are a formal education for the public, and the public would include both the employer and the employee. However, ignorance of the law is no excuse. So even though you might claim that you were ignorant to the breach, the law does not say that way. If you're going to be involved in a business, you could come and speak to the Chief Labor Officer, and he will guide you as to what must be done in relation to wages and those sort of things.
Okay, thank you.
Okay. Are there any other questions?
Mr. Mears, hi, good morning. Can you hear me?
Yes, not clearly. Can you?
Hi, Mr. Mears, can you hear me better now or no?
A little better.
Okay, I think I missed a question. I didn't hear you answer a question. I saw a question posed, and it was a question where the person was asking about having applied for one job and then the employer giving them another job. I saw that earlier in the chat.
I was not privy to that. The facilitators would see that. I wouldn't see that.
Right, yeah. So can you?
So you're saying that an employer employs a person under contract of employment for one job, and then gives him another job?
Yes, someone wrote something like that earlier in the chat as a question.
Could the person come on board and speak to me, since this is secondhand information? Could the person that posed the question in relation to being offered one job and then given the next, could that person come forward and pose the question?
Is there Shamar Jefferson? A Shamar Jefferson?
But let her come on and ask the question. Hunt. Yes, Mr. Hunt. Mr. Hunt, you might. I'm not hearing you. Good morning.
Hi, good morning. Yes, good morning. I have a follow-up question to about 3 questions ago. A lady was asking about employer calling an employee at the end of the day or the end of the month and making them redundant, for example, provided it was not a disciplinary matter. My question for you is, what if that employer makes the redundancy, let's say without notice, but includes notice in terms of all the other payments and whatever the employer but the employee is due by the employer?
The employee can still make a claim of unfair dismissal.
Okay. Thank you.
Okay. Ms. McLean. Ms. McLean, go ahead and pose a question.
Good morning.
Good morning.
My question, sorry for going back a bit, it is in reference to the Part B statement of particulars. Do you also have to have a written statement of particulars, or could it be also done verbally or orally with the employee when they start?
No, the law requires that it is a written statement of particulars.
So all that information relative has to be written. Okay.
Yes, it has to be written.
Right, thank you.
Okay, you're welcome. Are there any further questions?
Hi, good morning.
Good
I
morning.
had asked a question regarding an employment contract. If for whatever reason the employee is unable to locate their employment contract, can they ask their employer for the contract or for a copy of it? And if that request is refused by the employer, is that right? And if said request is made, is there a time frame in which they should be able to receive said contract?
There isn't any provisions on the law for refusing to administer another contract. The employee has a right to preserve the contract if he was given one, especially if he has signed for the contract. So you can't bully the employer to give you another contract. You heard what I said, Ms. Collymore?
I did, thanks.
Okay. All right, we have 5 more minutes. We would, I see I had a Lovell there. Could you go, Ms. Lovell?
Yes, good morning to all. My question is, if you are in an acting position, how long before you can apply for holiday and how much holiday are you entitled to before bringing your contract to end where it would be on pause until you return?
The contract is never on pause until you return. Holiday with pay is an entitlement under the law. So whether you're acting or not, you're entitled to holiday.
So you can take your full 28, whatever days, as opposed to just taking part of it?
You're talking as a government employee or as a regular employee, a private sector employee?
Government.
But then you need to speak to the Ministry of the Civil Service, who will guide you accordingly. That is not really, the Labor Department will not get involved in that.
Okay, thank you.
We have about 3 more minutes remaining. Julia King, go ahead and pose the question.
Hi, so the scenario that I posed in the chat was that of a manager volunteering to work at an alternate location because of the COVID environment, which would have caused the office to sever all other employees. So the manager is basically covering salesperson, still doing administrative duties, etc. But it has been a few years since that has happened. And it's kind of expected now of that person in that position to continue. Is it lawful that that happens without change of contract, without change of title, or would the manager wants to go back to doing the job she used to do? So I just want to know what are the options there for the manager? How does one approach a situation such as that?
You need to speak to the directors of the company. I guess that there would have been a tactical agreement to cover the areas that were left exposed because of COVID.
But that's the thing, there was none, and there has not been any discussion from directors within the recent months. So as I say, it was a volunteer approach because obviously persons they just want to make sure the companies don't close. So they try everything within their power to do what they can for the company. So without direction at this point, what can one really do?
Well, they need, like I said,
being insubordinate.
Well, they need to open dialogue with the company and look at their job description, the formal job description that they have.
Okay.
I indicate to the company that my job description said A, B, and C. During the COVID period, out of the goodness of my heart, I decided, because I had the interest in the company at heart, to do A, B, C, and D, or X, Y, and Z. So you need to open dialogue with the company, get a settlement in that, a resolution in that matter.
Okay.
Okay. All right, we will bring this session to a close. It is now 11:30. Let me thank everyone for participating. The questions were interesting and varied. Thanks again, and be safe. Bye. We will be back in 10 minutes to continue the other segment of this program.
Hi, good morning, everybody. Welcome back to the second part of our presentations this morning. Earlier, you would have been introduced to Mr. Lawson Mears, who would have taken the time to take you through the Statement of Employment Particulars and the first schedule under the Employment Rights Act. I am now tasked with taking you through the fourth schedule and the fifth schedule of the Employment Rights Act. Now, these two schedules speak primarily to disciplinary process, and if there is a lack of disciplinary process, what said compensation would look like. Along the presentation, I may, in between, ask a few questions to some of the participants, but similarly to how it transpired with Mr. Mears, at the end, you will have the opportunity to ask me whatever questions you may have. While we are going along, if something jumps out at you, just jot down a little note so you don't forget, so we can get as many questions as possible. On the back end, we will have two other labor officers, Mrs. Judy Trotman and also Mrs. Donna Bess Fredericks, that will be fielding some of the questions that you may pose in the chat throughout the presentation. I hope everyone got the opportunity to get up and stretch their feet a bit, knowing that in this new environment where we're on Zoom and you're sitting in the same place, it's good to still get up and stretch a bit. Before I start the presentation, I also want to extend a happy International Women's Day to all the ladies on the presentation, and I hope you guys have a good day. So let's get straight into the fourth and the fifth schedule of the Employment Rights Act. What is the Employment Rights Act? Mr. Mears would have alluded to this initially when he started his presentation. Now, the Employment Rights Act 2012-9, which is commonly referred to as the ERA, is an act to make new provisions for the rights of the employed persons and for related matters. You would have had the definition earlier from Mr. Mears about the employed persons, who's an employee, subcontractors, and also for related matters. So there's certain aspects of the Employment Rights Act that usually jump out at persons. It's a document that has in various different points that you can look at. However, listed here are some of the points that would normally come up often while dealing with the Employment Rights Act. So you have a contract of employment, statement of employment particulars, continuous employment, the notice or notice period, what is deemed as fair and in some instances unfair dismissal, layoffs, and redundancies. Now, all of these things usually go hand in hand when you're dealing with the fourth schedule of the Employment Rights Act. They come in at some point along the way. So the fourth schedule speaks to dismissal and the disciplinary procedures. Now, Part A points out rules to be taken into an account. Progressive discipline, that is the first point. Progressive discipline basically is when a person commits what may be deemed as an offense. It may not be a dismissible offense right off the bat. So the legislation looks at how you progressively get to the stage of what may be a termination. So forms of progressive discipline could be verbal warnings, then you proceed from verbal warning to a written warning, from written warning maybe to a suspension without pay, and then all the way up to termination. Now I mentioned suspension and I said suspension without pay specifically. Suspension, when persons hear suspension, they think it is one and the same. Suspension is broken down into two categories: suspension with pay and suspension without pay. Now, a person may argue that suspension with pay is pretty much a vacation. I've heard that before. But how suspension with pay works and how it comes about is that suspension with pay is when an employer is investigating a matter. So classic example, something would have transpired at the workplace and the employer wants to investigate and speak to all the persons involved to see who may be at fault or not. While he is doing that, he places person A or person A and B on suspension. They're usually placed on suspension with pay pending an investigation. Whereas suspension without pay is deemed as a punishment, a discipline. So you cannot put a person on suspension without pay and then turn around and dismiss them for the same infraction, because what you would have effectively done is punish the person twice for the same offense. So that's the difference between suspension with pay and suspension without pay. So progressive discipline is the first thing we look at. And then we go to the next point. No dismissal after the first breach unless it is gross misconduct. So similarly to progressive discipline, an issue arises, let's say a person is coming to work late. They got to work late, they're supposed to start at 9, they got in at 10. And the employer decides, I'm going to terminate you because you were an hour late. The legislation does not speak to that, or should I say, does not encourage that, similar to good industrial relations practice, because it's a first breach and being late is not deemed gross misconduct. So you would expect that the person is spoken to, whether it be verbal or given a warning letter, and given time to make the necessary adjustment. And that ties straight into the third point. The third point speaks to breaches of discipline not amounting to gross misconduct. Similarly to warnings. So when you give a person a warning, that warning is not to say, okay, you got to work late, so I'm warning you. It is also to say you got to work late, so I'm giving you the opportunity, sorry about that. I'm giving you the opportunity to fix the problem. So if you're going to give a person a warning, it is expected that you give them time to make the necessary correction. And the final point speaks to an expunge period. An expunge period ties directly into the written warnings. So you give John Brown a written warning on the 1st of December 2020 for being late. Let's use that again. John Brown has this written warning on the 1st of December 2020. On the 1st or 5th of December 2023, you want to terminate John Brown for being late. So then you pull the first warning that he was given from 2020, tie it in with a warning from 2023, and you say, look, I have 2 warnings, I'm going to terminate you as a result. It does not work that way because of the same expunge period. And the expunge period is a 12-month period, 1 year. So when you issue a warning letter, that warning letter stays valid for 12 months, for 1 year. If you go after that 1 year period, then that particular warning is expunged. So a person may have a warning the 1st of January, they may have another one the 5th of May, they may have a third one sometime in September. The following year, from the time you reach February, the first warning you initially gave in January is no longer null and void, that's expunged. All right, so we go on to Part B. Part B has various steps. Step 1 of Part B says there's a statement of grounds for action and an invitation to the meeting. Now, let me point out here, the 4th schedule speaks to disciplinary procedures. A written warning is discipline, suspension without pay is discipline, termination is discipline. So basically, the procedures that you will see outlined here in the 4th schedule are the procedures that you would need to go through to do all of these things: written warnings, suspension, and discipline. So step 1 says the employer must, 1, settle in writing the alleged misconduct, and 2, give the employee a statement inviting them to a meeting along with their representative. So you have a situation where a person prepared a report but did it incorrectly, and you wanted to discipline them for it. The legislation is stating here at step 1 that what is expected, it says must, by the employer, is that the employer sets out in writing, and we must remember that with this piece of legislation and these particular schedules, everything is done in writing, so you can keep a paper trail and a track of everything that is done and said. So the employer must settle in writing the alleged misconduct. So you state in the letter and give the person an invitation to a meeting with their representative. So you state in that letter, you're being invited to a disciplinary hearing on the 5th of November. It is in relation to you, and you set out exactly what the alleged misconduct was. You prepared a document incorrectly and it brought the company into misrepute or disrepute on whatever day. Then you also state in that invitation that the person has a right to have a representative present at said meeting. That letter of invitation must also state when it is, where it will be held, and who will be present. Step 2 goes on now to the meeting, when the meeting is actually taking place. So it says the meeting must take place A, before disciplinary action is taken, and B, within 7 days of giving an employee a statement, where reasonably practicable. Now we must remember with these pieces of legislation, reason is very important. Everything should be done within reason, because you have a situation where you're going to invite a person to a disciplinary hearing and they did an action on Saturday, you investigated it on Saturday, and you issue them with a letter of invitation to a disciplinary hearing from Monday morning. That is not being reasonable, because you need to give that person time to look at what the charges are and also have time to get a representative present. Now, the legislation is not explicit and says it has to be 7 days, 8 days, 10 days, but you need to be reasonable. So a good reasonable time is usually seen 3 to 4 days. That is reasonable time. Now, it also says that within the 7 days of the person receiving that statement, that this meeting should take place. Now, when it points on and says we're reasonably practicable, there are certain extenuating circumstances that may come about that will stop that meeting from going on within the 7 days. So after you've issued a person with a letter of invitation to a meeting, there's the possibility that that person may take sick and they send in a doctor's certificate going on sick leave. It is not expected that even when the person is on sick leave that you still carry out the meeting. So that is a classic example of where reasonably practicable that the meeting can happen within the 7 days. Step 2 goes on to say, the meeting must not take place unless A, the employee is informed of their right to have someone present at the meeting and the basis of the grounds of the meeting, which was explained earlier. And B, the employee has been granted reasonable opportunity to consider their response. So that ties in to the point I made just now about reasonableness. And point A speaks to giving that person the right to have someone present at the meeting and also knowing the charges that they are actually going to respond to. It goes on to say at point 3, the employee must take all reasonable steps to attend the meeting. Point 4, an employer must inform the employee of his decision and also notify the employee of the right to appeal the decision if not satisfied. There's a note at the bottom that says the decision and the right to appeal should be in writing. So at point 4 comes in after the meeting has been held and the employer management team has decided, after hearing all the facts of the meeting, what course of action or discipline they will take. So you have the meeting on Monday. Let's go from the beginning. An infraction occurred on Thursday, the previous week. The employer issued a letter of invitation to the employee, giving them the right to have a representative present, the date, time, and location of the meeting, and a brief summary of exactly what the charges are that they are supposed to answer to. The employee is given that letter of invitation. The meeting comes up the Tuesday of the following week. We had the meeting, the employee took all the reasonable steps to attend, no one was on sick leave, everything went ahead as planned. After the meeting, the employer then goes back, analyzes what would have been said at the meeting, all the facts that he would have gathered from his investigation, and possibly the Wednesday or Thursday after the meeting would have been held the Tuesday, gives the employee what the company's decision is in terms of discipline. So you're either going to discipline or you're not. And if you're going to discipline, what form of discipline? And when that is stated within that letter, the employer must give the employee the right to appeal that decision. Because it's tied in line with natural justice and giving the person a right to say, look, I'm not in agreement with this. No, I must make it clear. Because an employer gives an employee the right to appeal does not necessarily mean that when the employee appeals, that the discipline or the decision will change, but you have been granted that right. So it continues to say at step 3, the appeal. So after you've been given the letter and the right to appeal, it says the appeal must be done in writing. So when the employee receives that letter from the employer stating that they have the right to appeal, and they decide, yes, you know what, I'm going to appeal this decision, you must send that appeal to the employer in writing. So a brief letter stating, I would have received the decision on XY date, and I have decided to exercise my right to appeal this decision. And you put that in writing. It doesn't have to be too long, just something stating clearly who you are, what decision was given, and the fact that you want to appeal the decision. So that decision then, that appeal is then done at the company level, where management says, well, look, person A wants to appeal this decision. Let's hear them again, see what they have to say, and see if it's going to change our mind. I would like to make it clear here that when this appeal is being done, it is not good practice that the person who would have originally made the decision to discipline is the same person that is on the panel when they're doing the appeal. So if you have an HR manager and the HR manager says, my decision is that we will terminate Mr. Jones, and Mr. Jones decides to appeal that termination, then when he goes to the appeal meeting, he should not then be appealing to the same manager, because that manager would have already made the decision and there's great possibility for a bias. So it should then go a step further. So not the HR manager, probably the general manager. There are some companies that may not have that structure where you have an HR and then a general manager. What some people can do, or it may be a situation where the general manager made the decision. What you can do is employ somebody neutral, whether it be an attorney, an industrial relations professional, someone to sit on that appeal meeting and hear out the facts from the beginning to make a decision that will not be deemed as a bias one. Also, that appeal must go through the disciplinary process set out by the workplace. Now, if for whatever reason the employer or the employee is not satisfied with how the appeal meeting goes or went, then they can refer the matter to the Chief Labor Officer for a conciliation. Now, when this matter is being referred to the Chief Labor Officer, please ensure that when you're making that appeal and that referral, that the person who has been disciplined, the employee, is the person to sign that appeal letter or a trade union member. We have instances where attorneys may make the appeal on behalf of the employee, and that is fine. An attorney can draft the letter, but it is best to have the employee sign the letter and not the attorney Jamal Jones acting on behalf of Tom Brown making the appeal. The person, the employee, must be the one to make that appeal. Part C of the 4th schedule speaks to modified disciplinary procedures. And modified disciplinary procedures is basically matters that are deemed gross misconduct. So I would have given examples along the presentation about persons being late for work, persons doing work not to the best of their ability, putting the company in disrepute, different little scenarios. However, modified disciplinary procedures, Part C, speaks to, like I said, gross misconduct. Now, gross misconduct may be different from organization to organization. There are certain things that will be deemed as gross misconduct across the board, but it goes according to organization. And let me give an example of why I say organization. Let's say you are working at a construction firm. The norm on construction sites would be persons cursing and using abusive language. That is just how they operate when they're on a construction site. So that may be allowed on a construction site. However, that same language, that same behavior will not be allowed if you're working within, let's say, a doctor's office. So gross misconduct in a doctor's office may be cursing and using of abusive language, but it may not be that on a construction site. However, there are certain things, like I said, that are deemed gross misconduct across the board. So you have employees who get into physical altercations, start fighting on the job. Misappropriation of funds, what some people may deem theft from the company. Being physically, and in some instances, verbally abusive to the employer. Those things across the board are usually deemed gross misconduct. So this modified disciplinary procedures, this section speaks to those particular matters. And it says here, when an employer decides he's going to terminate a person for gross misconduct, he must issue a letter in writing stated what the alleged misconduct was, his reason for dismissal, and he must also give the employee the right to appeal the decision. And B says, give the employee a copy of this statement. Now, anyone looking through this would say, well, it's similar to what was done in Part B. What's the difference? The difference here is with gross misconduct and modified disciplinary procedures, persons are usually terminated instantly, summarily. So you have two persons fight on the job, you terminate them right there and then send them off the job. And then you put these things in writing, what they would have done, their reason for dismissal and their right to appeal, and you give that person that letter, whether it be later in the day, the following day. That is different to Part B, where a person is late and you give them a letter inviting them to a disciplinary hearing, stating what day it is, and then you go through that process. Because gross misconduct, you want that stamped out instantly and you want the persons off the compound. So that's the difference between the Part C and Part B. Part C continues The person, like I said, must be given the right to appeal. And the appeal, once again, similarly to Part B, must be done in writing. And once referred to the Chief Labor Officer for conciliation, it must be signed by the employee or a member of the trade union. So that encompasses the fourth schedule, the disciplinary procedures. Now, I'm sure there are persons with lots of questions, and we're going to start to tackle some of those questions shortly. What I would like to do first is go through the fifth schedule, which points out how compensation is arrived when persons do not follow the fourth schedule. So let me state here the legislation, the Employment Rights Act. When a matter goes for conciliation and you're trying to determine if a person has been unfairly terminated, there are 3 remedies for that unfair termination. Those 3 remedies are you reinstate the person, which means they go back to work after they've been found innocent. They go back to work like nothing has changed, same pay, same tasks, same duties, everything. Re-engagement, the person is re-engaged in the organization. They may be doing another job, a different task, maybe at a different pay, but they're still with the organization, so they're re-engaged. And the final one would be compensation. Now, compensation comes about if the first 2 are not an option. And those 2 may not be an option for the employer or the employee, because the employee may say, I'm not comfortable going back to the organization after I was treated this particular way. So they would then seek compensation. The employer may say, I don't want this person back at my establishment for fear that something else may happen. So they may also go the route of compensation. And that is where the fifth schedule then comes into play. Now, the fifth schedule speaks to basic award under the legislation. And the legislation, as Mr. Mears would have pointed out, a person can make a claim of unfair dismissal only if they have been employed for 1 year or more. Nothing under that. Now, you can have a matter addressed if you've been there, let's say, for 6 months, 8 months. You can speak to a labor officer and have the matter addressed and assessed. However, to make a claim of unfair dismissal, you need to be employed for 1 year or more. So the basic award here sets out the periods of employment versus the amount that a person may be entitled to. So you can see 1 to 2 years, person is entitled to 5 weeks wages compensation. 2 to 10 years, 2 to 5 weeks wages for each year of that period. 10 to 20 years, it goes to 3 weeks wages for each year. And 20 to 33 years, 3.5 weeks wages for each year. Now, persons may look at this and say it is similar to how severance is done. Now, there are 2 differences between the basic award as compensation under the 5th schedule of the ERA and the Severance Payment Act. The severance payment takes into account your last 2 years of service, and then they divide that last 2 years, or total gross earnings for that last 2 years, divide it by 104 to reach your average weekly wage, and then they would apply their weekly amounts, which is similar to 1 to 10 years. So they would take that average weekly wage, multiply it by the 2.5 weeks of each year for the number of completed years. Now, in arriving at the week's wage under the 5th schedule with compensation, the legislation does not go back the 2 years. You can go back as short as 12 weeks. Total gross for the 12 weeks, divide it by 12 and you get a weekly wage. And then you use that weekly wage. The other difference is with the severance payment that pays 2.5 weeks for the first 10 years. And then when you go into the next 10, it pays 3. So you would take a tally of the first 10 at 2.5, and then the next 10 at 3, and you sum them together. The compensation under the 5th schedule, from the time you get into 10 years, 10 to 20 years, they're looking at 3 weeks. But the difference is it starts from the inception. So it is not 1 to 10 by 2.5 plus 10 to 20 at 3. it is 1 to 20 at 3 from the inception. And it goes on to the 33 years as stated in the table here presented. Note, the tribunal may also award any amount they believe the employee might reasonably be expected to have if they were not dismissed, and in some cases, an amount not exceeding 52 weeks' wages. So this is if a claim of unfair dismissal has been made and it has been deemed that the employer did not follow the processes set out in the fourth schedule, and as a right, the employee has a claim for unfair dismissal and to compensation. The tribunal may impose an award up to 52 weeks. I made another note that says, and I explained it just now, compensation is not calculated the same way as severance payment. Now, at this point, I would like to pause for a minute and allow you the opportunity to ask any questions that you may have. And then we will go into a few scenarios and a few questions to see if you have grasped what I would have presented with respect to the fourth schedule and the fifth schedule. So I'm going to give you the opportunity now to ask any questions that you may have. You can just raise your hand and I'll select you and let you answer your question openly. Go ahead, Zoom user.
Good morning. Good morning.
Hi, good morning.
That's Paige. I have to ask a question regarding the disciplinary procedure. If you have a meeting, you talk about reasonable time. If you have a meeting, say in November, and gets back to the person with the disciplinary action in January, is that reasonable time?
No, that time is definitely not reasonable. Remember, I would have stated reasonable time, and I also stated extenuating circumstances. So only if there was an extenuating circumstance. So let's say the meeting was conducted and the employer wanted to get back to the employee with their decision. Right off the bat, that is just about 2 months. That is definitely unreasonable time. Definitely. Even in an extenuating circumstance, you may have a situation where, let's say, the employer may have gone on sick leave for an extended period of time. I would like to believe that there's someone else that will be able to follow on from where that was, to take up the mantle and say, well, look, this is the decision that the company has come to. But to have a person have a meeting in November and sit down and wait until January to give them a decision, that is definitely not reasonable.
Right, and if after now, say you got a final warning, and then you were terminated in February for a subsequent, another disciplinary meeting, but they are citing the charges in the first meeting. I think that is that considered fair?
I'm trying to be clear, and you can tell me if I understand what you're saying. You would have had a disciplinary meeting on one incident, and then another meeting came up a couple weeks, months down the road, and you're having a meeting with respect to that, and they tie in what happened at the first meeting.
Yes.
After the first meeting, was a decision reached after that first meeting?
After the first meeting, it was final warning.
Good.
After 2 months of waiting for that decision.
Right. So you had your answer with respect to what the charge, what the discipline was. You had a final warning.
Yes.
Now when you do this second meeting should be taken on its merit, what you would have done in this particular instance. So if you're terminated, let's say at the second meeting, it is not necessarily tied to the first meeting. they may point out the fact that at the first meeting you were given a final warning. So as a result now, the next step would be termination. Remember at the beginning of the presentation, I spoke about progressive discipline.
Yes.
So in the company, this may be their form of progression.
Progression.
They went through warnings, they gave you the final warning at the last instance, and now they're left now with the termination. So this may be the form of progressive discipline. However, I must state clearly, I am not in agreement with the fact that a meeting would have been held in November and you would have only received the decision in January. That is definitely a bit unreasonable.
And one last question. In terms of, you said that severance is on, not you, the other gentleman, I think, say severance is only paid upon redundancy. So if you were there for 3 years, the company will have any money for you after terminating your employment?
Right. So when he said with redundancy, no, severance payment of itself is only paid under certain circumstances. So as he rightly said, if the company makes you or the position redundant, let's say there was a natural disaster and the company had to close as a result of extreme damage, or maybe you were laid off for an extended period of time, past what the National Insurance Department sets out as their limit, then you are paid severance by the company. However, when you are terminated, because remember, when you're terminated now, you're terminated with cause based on something that you did. So there's not the company just bringing the employment to an end. Something you did caused this termination. So you're not paid severance then. However, if when you are terminated, it is deemed that your termination was unfairly done, this process that I explained, the fourth schedule and the fifth schedule, will look at compensation for the unfair dismissal. So it would not be deemed as severance, because severance only falls under those 3 specific categories I mentioned earlier.
Understood. Thank you.
Clear? Not a problem.
Yes, thank you.
Okay. Mr. Young.
Yes, thank you, sir.
Good morning, sir.
Was it correct in hearing you say that with respect to the modified disciplinary procedures, the employer can terminate instantly without going through the procedures in Part B? Am I correct in saying that?
Yes. If it is a case, if it is a case of gross misconduct. So the process is set out in Part B, where you go through the invitation to a disciplinary hearing and invitation to that hearing and the employer making the decision and then giving you the right to appeal. That particular process, the employer does not have to go through that if they are terminating a person for gross misconduct. So the example I gave is 2 individuals fighting on a construction site. Somebody, let's say, hit someone with a shovel. Now you're not going to have those persons remain at work. Well, the next day you give them a letter inviting them to a disciplinary hearing while they're still at work, remember. Inviting them to a disciplinary hearing, let's say the following week. You know outright what they have done is deemed gross misconduct and you're going to terminate them for it. You terminate that person citing gross misconduct, they leave the workplace, construction site, whatever you claim it. And then you prepare that letter stating, this is why I have terminated you, this is what you did, this is the reason for my decision. But you still give that person the right to make their appeal, to appeal the decision, so that they can be heard.
But we know that not living in a perfect world, there must be cases where the allegation against the employee is nebulous, not clear, not authentic. But in the mind of the employer, the evidence appears to be clear-cut and valid, strong enough to warrant instant dismissal. And then the employee is told, yes, you can appeal, you can go to the tribunal, and the rules of evidence will apply, and you might still get redress. It does seem to me that, and given the fact that the workplace is supposed to be an extension of a wider democratic society, the evidence against the employee in this instance, acquired through an investigation, may not validate the act of instant dismissal. And yes, you tell the employee now, he or she has to appeal. In the letter, you tell them this, and they appeal to the tribunal or to the employer.
To the employer. They appeal to the
would you say that and against, and given the whole nature of the power relationship in the employment sector, the employer has the upper hand and can virtually manipulate the situation and force the employee to hire a consultant or lawyer to go before the tribunal and get a correction, especially if you know in your heart that the evidence against you is not that strong.
Right. So you have a situation where you go through the process as set out by the legislation. So the employee may make the appeal to the employer. As you rightly said, the employer may have the upper hand. That does not stop the employee, after making the appeal to the employer, if they believe that they have not been given a fair hearing or chance, from coming to the chief labor officer. Once you get to the stage of the chief labor officer, then a conciliation meeting is held where the chief labor officer acts as the in-between, the mediator between the two parties being the employee and the employer. And if either party or both parties decide to bring representatives to that meeting, even at that stage, when you're at the chief labor officer and have the conciliation meeting, at the end of that meeting, if the employee is still of the belief that he was not given a fair opportunity or a fair hearing by the employer or the chief labor officer, it is at that stage then the matter is referred to the Employment Rights Tribunal for adjudication. So the fourth schedule is more about following the process that is set up. Now, a person can make a claim of unfair dismissal for any reason, but when you're looking at that claim, when that claim is being adjudicated, whether it be by the tribunal, chief labor officer, even down to the stage of the employer-employee, it is looking to see if the employer has followed the process set out in the fourth schedule of the Employment Rights Act. And if it is deemed that that employer has not followed that process, whether it be the appeal, whether it be the invitation to a disciplinary hearing, you name it, then that individual has a valid claim for unfair dismissal. Does that answer the question, Mr. Young? All right, I'll take your silence as a yes. All right, we have a question from Mr. Prescott, Gerard Prescott.
Hey, good morning.
Good morning.
Hear me?
Yes, sir. Go ahead.
Hey, morning. So I listened very attentively, and the question, the concern I have is where it goes from meeting, or where it changes from meeting to disciplinary meeting. I tell you why. In my procedures, I've never had disciplinary meetings. I always have meetings, and then based on the investigation, I then make recommendations. So I think I'm now understanding you. If I'm wrong, you can guide me. That you're saying that there are meetings and then there are disciplinary meetings.
Okay, so if you have a meeting to discuss, let's say, a person being late for work or an incident that happened where you're investigating it, you can have an investigatory meeting where you're pulling together facts. But from the time you are looking to discipline a person, and remember I said discipline could be written warnings, suspension without pay, termination. From the time you bring that person into a disciplinary hearing where you're going to make a decision to terminate or discipline that person for any reason, it is automatically deemed a disciplinary hearing because that is the outcome that you're looking to get out of the meeting, some form of discipline. So once that is set in place, then that person should be given the right to have a representative present. Now, if you're at the establishment as an employer, and let's say you're running a shop, and a client comes in and they had a disagreement with the cashier, and you come out and hear this commotion, and see this back and forth. You pull the cashier to a side, whether the client is gone or not. And you said, look, what exactly happened just now between you and the customer? And you all sit down and the person explains to you what happened, and you say, well, look, next time this is what you can do, etc. That is a meeting where you investigated what happened and you had a meeting with the employee. But from the time you have in the back of your mind, look, the way how Sharon behaved just now with our customer, I think I'm going to have to give her a letter or discipline her for it. It automatically then becomes a disciplinary hearing that you have to follow the steps to invite her to, which is issuing the letter of invitation and stating in that letter of invitation what the legislation says should be in that letter.
So this is where my challenge comes in. I follow the app.
All right.
So I have a staff member who is continuously creating issues, but I follow the app. I write you, I outline what the concerns are. I invite you to a meeting. I give you 7 days. I invite you to bring a representative. But in the back of my mind, I am still neutral as to what I will do until I hear from you. When I hear from you and I then deem that your excuse is not satisfactory, or is a situation where I've spoken to you on the matter more than once, then I recommend to my supervisor above me what disciplinary action we should take, whether it be a verbal warning, whether it be a first warning. So that's why I was confused about the difference between the meeting and the disciplinary meeting, because my style has always been to be a meeting, and then based on the evidence that you provide. It's like a man is charged, but he's guilty, he's innocent until proven guilty. And then when the jury hears the evidence, then they make the decision. So I'm just wondering if I'm doing it the right way.
Right. So remember, you said that you invite the person to this meeting, disciplinary hearing, and only then, when you're going through that meeting, you would make your decision after. What you said initially changes everything, because initially you said you've given this person all these different chances and they're still basically making the same mistake. And then they come to you and you have this particular matter to deal with. Right off the bat, in the back of your mind, you may be neutral as to what you will do at the end of the meeting. However, the fact that you invited that person on the basis that they would have done it X amount of times before means there's the possibility that you're contemplating discipline. And once that is there, then that becomes an invitation to a disciplinary hearing. So it does not say that because you invite a person to a disciplinary hearing that you have to discipline them. Because at that meeting, after you hear the facts and you discuss and they argue, you might say, look, okay, we just let this one slide. But it is better to have that process followed if you go ahead with the discipline than to do it, not have it followed, and then still go ahead with the discipline, because then you'll be falling into the legislation.
Okay, thanks.
Clear?
Yeah, thanks.
Cool, okay. Ms. Maynard?
Good morning to all. I have 2 questions. We know that the 4th schedule states that the meeting should take place within 7 working days where practicable. You went through that already. But I am aware through custom and practice of a 3-day, let's say an infraction occurs on Monday, and you are inviting this person, giving them the statement of grounds and inviting them to a disciplinary hearing. I am aware of a 3-day practice, as I said, through custom. I want to know if there's anything written anywhere that the person must have at least 3 days for that employee to prepare for this meeting. That's one. And the second question would be, if the meeting now was scheduled for the Friday after the infraction occurred, and on the Thursday evening, something came up. So the person chairing the meeting now was sick or what's not, but the meeting could no longer take place on Friday. Is there a need to extend the notice? Well, I know you have to let the person know the meeting is being rescheduled, but if all parties agree, could this meeting be, say, on Monday at the next available day, or is there a need to consider those 7 days again, or another 3-day notice period?
Okay. So the first question you would have asked is if they're, based on the custom and practice that you're aware of 3 days, if there's anything basically set in stone that says it has to be 3 days. And the answer to that is no. It basically speaks to reasonableness, as I would have mentioned before. And 3 days, 4 days would be deemed reasonable. If you issue a person with a letter of invitation to a meeting today for tomorrow, then that's definitely not reasonable. So that's where the 3 to 4 days will come into play. So even though it's a custom and practice, it is not written anywhere, but it is deemed as reasonable. Now, the second question that you mentioned is the meeting is scheduled, you give the person the invitation the Monday, the meeting is scheduled for the Friday. The Thursday evening, something occurs that Friday meeting cannot take place, and you want to put it off until the Monday of the following week. Now, you do not have to start over the process and give another 3 or 4 days in terms of reasonableness. However, you need to factor in when the person is looking, because they have made arrangements to have their representative there for the Friday. So there's the possibility that the representative may not be able to make it the Monday. Now, as the company that made the, I don't want to say mistake, but for whatever reason, they can't have the meeting on the Friday anymore, you must express that to the employee and their representative, and also then look at then what would be a reasonable time based on their time constraints or what they may have planned for the following week. Now, if the representative says, well, Monday is fine by me, and the employee says Monday is fine by me and it's good for you all, the company, then that's fine, that's not a problem. But you don't have to say, oh, okay, this happened on Thursday evening, so I have to wait now Wednesday or Thursday next week. It doesn't have to be like that. Once the time is available for everybody, because they've already been aware that it was supposed to happen, then you should be fine.
Okay, thank you.
No problem. Mr. Prescott?
Sorry, I'm gonna take a man.
Oh, okay. Chef, you have a question? Just on mute.
Hi there, can you hear me?
Yes, go ahead.
Hi. In terms of the vacation law or holiday pay and that kind of thing, are employers allowed to, like after you work 1 year, are employers allowed to give you a specific time that they would like you to go, even if it's after a year? Or is it up to the employee to let them know as to which day or whatnot that they will be going off on vacation?
Okay, all right. So that question is slightly off topic. I will still
Yeah,
answer it.
sorry.
That's all right. I'll still answer the question, but maybe you should join into our session on Thursday morning that will speak more directly to holiday pay. However, to answer your question, yes, a person is entitled to vacation and holiday pay after a year of employment. Now, you may have started, let's say, January 2019. So you're saying to yourself, in January 2020, I'm entitled to vacation, so I want to have my vacation then. However, the law allows the employer to withhold that vacation for up to 6 months after it is due. Now, because there is the allowance to withhold the vacation does not automatically mean or necessarily mean that the employer will do such, but they can do that. Because let's say you work in merchandising or sales in Bridgetown. You started in December. So you're expecting to have your vacation in December. Now, everyone knows with December at Christmas, that's the busy time. So most employers would prefer to have all staff and all hands on deck during that time. So for that reason, the employer can withhold that vacation, let's say until January or February, once it is within the 6 months after it is due.
Okay.
Yeah.
Yes. Okay, I had kind of 2 more questions, but it's off topic.
Oh, on holiday pay as well?
In terms of payment, not payment, but raise in pay, like after 3 months and that kind of thing.
Mm-hmm.
And
we're here now. Let's answer the question. Go ahead.
Okay, right. So after 3 months, is it a law that they have to raise your pay, or is it with the employers? Is it up to the employer?
It is not a law, and the fact that you're mentioning 3 months specifically, I'm assuming you're talking about a probationary period.
Yes.
So if you're speaking about a probationary period, it depends on what your contract of employment and statement of particulars may say, as Mr. Ramirez would have explained earlier. So one company may have a contract of employment that says the probationary period is 3 months, and after you've passed probation for that 3 months, then we're going to increase your pay by 10% or $50.
Okay, not cutting you, but what if there's no probation?
So we're not talking about probationary period?
Like, okay, let's say you got hired,
mm-hmm.
and they say to you that your pay will start at a specific amount.
Right.
But, well, technically there's no probation period. They're just telling you that this is your pay.
Mm-hmm.
Is it mandatory that that pay goes up after a certain time?
No. Like you said, if you start the job and they say you're starting at $2,000 a month, and they say after 3 months, they're going to raise it by $500. First things first, usually if they're going to increase that pay, there are usually conditions attached to it, whether it be performance, if you're in sales, the amount of sales you make, something to measure, the reason why they're going to give you the increase. However, if there's nothing that says that, which I would find very strange, that they say after 3 months they're going to raise your salary and you're still there and they don't complain about anything, then they'll have to work accordingly to the contract of employment that they will set up with you.
Okay. One final question. I was made aware, unfortunately, I didn't know about this earlier. I was made aware that there was a law passed in 2015 about if you were called in or if you're scheduled to work on your off day or whatnot, that you were supposed to get double pay. I'm correct?
Yeah.
Right. Let's say an employer was not adhering to that law. Would that employer owe anything to their employee?
Well, first things first, if the employer is not adhering to that law, which means the employee has found that out, the duty of the employee is to inform the employer. And even if after doing that, the employer does not, let's say, take them on, for lack of a better term, then you have recourse by coming to the chief labor officer to have the matter looked into. However, similarly to other things, like for instance, holiday pay, you have persons that would visit the department and say, I've been working for 7 years now, and I've only received one holiday pay my first year. So now that I am aware that I'm entitled to holiday, and in this instance, entitled to double pay on the bank holidays, the day that they come into the off day, I want all the money for all those years past that I didn't get it. No, it does not work like that. It does not work like that. We would deal with it from the time it comes. Now, if it is something that happened, let's say last week, or maybe the week before, then we can look into it, definitely. But to come to the department and say, 2 years ago, I worked on my off day and I didn't get paid double time for it, I want my money, no, it would not work like that.
Okay, so going forward now, what will be the employer's steps going forward in that instance?
Employers or the employees?
Correct their action?
The employer or employee?
The employer.
Yes, they should correct their actions, definitely. And at that point in time, because you're aware now, and they do not correct their actions, that is when you make that claim to the labor department.
Okay, understood.
Good?
So, yes, thank you very much. That's it for me.
No problem. Kelly, Ms. Walks.
Hi, good morning. A very quick question. Just going back to termination for cause. My query is just around, is the employer required to, once we've terminated for cause, is the employer required to include in that termination letter to the employee that they have a right to appeal? Do we need to put that language in there?
Most definitely, because if you do not, then you are in breach of that same 4th schedule, and then the person can make that claim for unfair dismissal.
Okay, okay, thank you very much.
No problem. Ms. Butcher, Rhonda?
Yes, my question. I find that this thing that we're talking about, it kind of disadvantages a person in a small business, because I find since it came into being, I find a different attitude toward workers have towards employers, because once upon a time you get vexed with an employee and that's it, but it doesn't happen that way anymore. I find that because employees know that they tend to not perform some things as you should. Like, suppose I have just one employee responsible for, say I have a little store, and that employee is not doing her duty. And even though you tell them what you expect, they're still not doing their duty. How do I go about getting that rectified? Because I know you cannot terminate the person just like that, right? What recourse do I have? Do I have to give warnings? I mean, give warnings, then that person dealing alone with your customer, when you come and you don't know about what kind of attitude they will display there. So in a case like that, what do you do?
Okay, so I will start by agreeing with you that after this legislation came into place, it will be a little bit more difficult and time consuming on smaller businesses. So I do agree with that. However, what I don't agree with is the point that you have made, and other employers have made it as well, that basically the legislation is for the employees and has given them the right to do as they like. And that is definitely not the case. What it really takes is for sessions like this, discussions, employers to take the opportunity and the time to read the legislation and understand, and also put these things in practice. Because the more you put them in practice, the easier they become. They become natural. So you would have pointed out that before this legislation came about, the employers were able to just terminate a person just like that. That is also one of the reasons why this legislation came up. Because then you had situations where persons might have been working for an employer for 25 years and then decided, you know what, I don't want Mr. Jones here anymore. Give me a week's notice and send me home, and that was it. Now that is not fair, because I could not have been a bad employee and been with you for 25 years. But you had the option that you can just terminate me without following any sorts of procedure whatsoever. The legislation that is in place now does not stop an employer from terminating an employee. You, at the end of the day, as an employer or management, have the right to manage your business. All this legislation does is bring fairness to the table, where if you're going to terminate me for whatever infraction, something I did that does not help your business, I breached some sort of legislation, I breached your code of conduct, whatever the case is, you have the right to terminate me. You just need to follow the process, the steps that I outlined earlier. And even though it may seem tedious, it really is not once you get the hang of it, because it is simply this. You're giving the person an invitation to a meeting to discuss what you want to terminate or discipline for, allowing them to have someone to represent them, because in all fairness, everybody will not be in a position to represent themselves. They may not be able to speak firmly enough to represent themselves. Some people cannot read or write. So they will have someone to represent them throughout the process. And once you have made that decision, you're just giving them the right to appeal. And it is nothing different from what would happen in a court setting. You go down the street, someone tries to snatch your bag, you slap them with a piece of wood around the head. You wouldn't like to go to court and say, oh, we're going to charge Ms. Butcher because she slapped the guy around the head with a piece of wood and lock her away in jail. You would like the opportunity to defend yourself and say, but look, this guy tried to snatch my bag and I was defending myself. It is basically the same concept, just in industrial relations format.
But you know how much tension is created in the workplace then when you're going through that process of discipline one member? You know how much tension and negative vibes and everything and that didn't exist in the workplace?
The unfortunate thing about employment and being employers and actually just living as a human being is that everything will not always be harmonious and everything will not always run smoothly. So there will be times that if you have to pull up an employee on something they have done, that there will be tension. But the aim is not to hold on to the tension. The aim is to follow the legislation, follow the law, and do what is right, one, for the employee, and two, for your business. So you cannot run a business thinking, oh, I'm going to run this business. Or it's like me saying, I'm going to open a store selling clothes in town. And everybody that I employ, I will let them do as they like because I don't want any tension. It doesn't make any sense doing it.
It comes down to that often.
Yeah.
Because they just want peace and harmony and team spirit.
Yeah, we all want that. We all want that on a daily basis, not even necessarily with employment. But you don't always get what you want, unfortunately. It's just
I have another question though. Suppose I wanted to restructure my business. Could I pay everybody severance pay and just start fresh, or that's not?
All right. If you were in the session earlier with Mr. Mears, you would have heard Mr. Mears mention if you're looking to do redundancies and restructurings, once you have more than 10% of the complement being restructured, then you need to have a consultation with them at least 6 weeks beforehand. Now, you would have made the example that you're a small business and you may just have one employee. So if you just have one employee, or even if you had two employees, automatically, if you're going to make one person or two people redundant by restructuring, you're definitely over 10% because one employee is 100 and two is 50. So you would still need to have some sort of consultation at least six weeks prior to making the decision so that the person knows why you're doing the restructuring, why they're being impacted, and if there was anything else that could have been done, to save them in the process. But doing that does not stop you from having the right to restructure your business. So do not misunderstand me. You can still restructure your business for whatever reason, financial reasons. A lot of people went through that during the whole COVID pandemic. Not that it is over, but we are on the better side of it now. So a lot of that would have transpired, but you still need to follow the steps and the processes set out in the legislation while doing it.
So can you pay the severance pay and invite the employees to reapply for different positions that you may have?
After you have done after you would have gone through what I just explained, yes, that's something that you can do. Okay.
Thank you.
No problem. It's smart.
Hi, good morning. First I want to apologize for going off topic, but it just came up when the other person talked about vacation pay. I think it's two questions. Vacation pay, I would have heard it was mentioned before you're entitled to vacation pay 1 year after your date of employment.
Mm-hmm.
I was under the belief that it was actually 9 months. So is it 9 months if you're being terminated before the 12 months that you're entitled to 3 weeks vacation pay if you're being terminated before the 12 months? Or is that something that is actually not 9 months? Or is that something that between you and the employer?
No, it is not 9 months. It is 12 months, a year of employment. You may be a situation where you've been employed for 9 months, and then after that 9 months, you may be terminated or you decide to resign. If you do that, then you're still entitled to your holiday pay. The only difference is you will not get the full holiday pay that you would get for a year of employment. You would just get average or prorated part for that 9 months if you've been employed for 9 months.
Oh, okay. And the other question, it was stated before the double pay. Okay, so I was under the impression, well, I want to clarify, if I am off on Wednesdays and my employer asked me to come in the Tuesday, if I can come in the Wednesday, would it be double pay or would it be time and a half? Because they told me before the off day.
All right. You said you're off on Wednesday.
Wednesday. I was advised on Tuesday. I was asked to come in on Wednesday, which is my off day, and not the same day, whereby I would have been called out on the Wednesday, because I think it's double pay when you're home and the person call you on your actual off day.
All right, not to cut you, let me just try to clarify this as simply as I can. If you're called out on your off day, you're paid double. And the time half that you mentioned, time and a half, is in respect of overtime.
Overtime.
Overtime is more than 8 hours in a day, and cumulative more than 40 hours in a week.
Okay, so if I'm told to come to work on the Wednesday to Tuesday, what would that be? Double or time and a half?
It would be double because you're coming on your off day. It doesn't matter if you are told the Tuesday, the Monday, or the same Wednesday. What is important is if you do come on your off day, then you're paid double for it.
Okay, and that would be even on Sundays. How is Sunday considered a normal working day, whereby if I'm asked to come work on Sunday, would I be given, would the employer have to give me 2 days basically between the Monday and the Saturday, or how does that go?
If it is, it depends on your organization and how it's set up. If Sunday is a normal working day and you work Sunday as one of the days, then you're expected to have 2 other days off in the week, because it is a 5-day week with 2 days off. Okay.
And you're entitled, I'm just trying to confirm what belief over the years. You're actually entitled 2 off days, whereby one is weekend and one is during the week as well.
It doesn't have to be weekend. It doesn't stipulate that it has to be weekend. It just says you're entitled to 2 off days.
Okay, so I always thought it was one was your day of belief, I guess, like Christianity or something.
Yeah, one is your religious day of worship, but my religious day of worship may be a Wednesday.
Oh, okay.
So it doesn't have to be a weekend.
Oh, okay, I understand.
But you could join into the session that we're going to have on Thursday.
Yes, please.
10:40 p.m. a.m. Sorry. And that would speak to employment leave, and would also factor in some forms of holiday pay and stuff as well.
Okay, no problem. Thank you very much.
No problem.
Thank you. Bye-bye.
Bye-bye. Ms. Pitt, you have a question?
Yes, please. I know we're speaking about wrongful dismissal. Being laid off is a form of being terminated.
If layoff is a form of being terminated? No, please.
Yes, please.
When you're laid off, you're still employed.
Oh, so say that I was laid off in January for 4 weeks, and I'm supposed to return to work in February, and on the date that I was supposed to return, they say that I have another 4 weeks.
Right.
I wasn't paid through NIS. I didn't get like an NIS check or anything. It's now March, and I haven't heard anything from them.
Right. So you said you were laid off and they extended the layoff period. Now you said you have not received a check from the NAS. What I would like to say is that you have not received a check from the NAS as yet. Because if it is a situation where you were employed and you were paying your NAS, the company was paying it in, and you have your contributions at the National Insurance Department, that is where you would get your payments from. Because like I said, layoff, while you're on layoff, you are still employed. And there's a period of weeks that the NAS department would deem that you're still employed. And once you have not gone past that extended period, then you are still employed, and the National Insurance Department would make the payments.
Okay, so say in January when they first laid me off, they paid me money.
What was this money for?
January, I assume.
What you may need to do, it sounds like you may need to speak to the NIS department, because if they paid you money, but yet you were still laid off, the two are not adding up, to be honest, because when you're laid off, then you get your payments from the National Insurance Department. So you might need to follow up with the National Insurance Department and see exactly, excuse me, what the status is there.
Okay. So then in terms now, being on that is March, because I'm laid off from January and February, being on it is March, and they're saying that they'll get back to me. It's now, the state said on the 7th of March. No one got back to me, so I'm assuming that I'll be terminated. So
No,
I am not
no,
sure.
don't assume you're terminated. Let me just make something clear. I'm going to answer your questions, and this is for other persons as well. But let's try to stick to the 4th and 5th schedule so we don't go too far off topic. However, Ms. Pitt, to answer your question, the National Insurance Department would stipulate a period of 13 consecutive weeks that you can be laid off for. Now, you said you were laid off in January, and it is now the beginning of March, and you have not heard anything as yet. Technically, that is just about 9 weeks, roughly. So you can still be on layoff, like I said, up to that period of 13 weeks. Approaching that time, the company will or should reach out to you with respect to your expected return date. How long have you been employed?
About 6 months.
6 months?
Roughly 6 to 7 months, yeah.
Oh.
They said the reason for the layoff was because things would be slow in January.
You would need to reach out to the National Insurance Department, but like I said, the company is still within their time with respect to the layoff period.
Okay.
Okay. Mr. Young, you have a question?
Yes, thank you. I'm glad you clarified the issue of the role of the representative of the employee at a disciplinary hearing, because there are some schools of thought. There are two schools of thought. One is that the disciplinary hearing is a management right and a process controlled by management, and therefore the employee's rep is not entitled to have any say in the circumstances. The other school is that in a society where people are not as vocal and verbal as they should be, the reason for the representative there is to ensure justice and fairness in the way how the process evolves. So I'm very glad you made that point, and it's something that I believe the law should clarify and correct, because right now they're silent on it, on the role of the representative, even though it's implied. It is implied. And I am glad you articulated the position that because many of our employees are not very articulate, consequently, the presence of the representative ensures some fairness and balance in the way how the process of disciplinary hearing is conducted, especially since the employee is innocent until found guilty.
All right.
So I want to thank you for that, and I would like to hear you on that, because it's something that I know came up at a meeting, a conference that HERMAB had with the employers on the role of the third party, short-sword, lawyer, or friend, as the case may be.
Well, what I would like to add here, though, Mr. Young, I appreciate your sentiments. But what I would like to add here, though, is even though the representative is allowed to do those things with respect to, a person not being so articulate and what's not, it is not expected that the representative come and try to, for lack of a better term, bully the proceedings. You still let the management handle the proceedings, and they do the ones that directing how the session goes. But you have instances where the representatives come and try to take over the meeting. So yes, I take your point, but I wouldn't want that to go to the extreme end of things where the representative tries to take over the meeting from the employer.
And let me just say here, I've seen in my reading cases where IR cultures in which employees are prepared to represent themselves at hearing. So even in the industrialized countries, it's recognized that employees are disadvantaged when the evidence being tendered at the hearing is stacked against them. And consequently, there are programs now being organized, and maybe we need to set this in Barbados, where the unions or non-governmental organizations or the church should start preparing the employees to face this predicament, which is likely to happen to many people throughout their working lives. If you ask a question of students at a training session, you get zero replies. Farthest when they're under stress of a threat of a disciplinary action, people panic and consequently the decision goes against them. So I take a point about not bullying the session because that is unethical and businesslike. But certainly we must recognize the right in a society where the employers have the upper hand in the employment relationship for employees who are under disciplinary hearings to be effectively represented. Thank you.
That's why we would have these sessions, so we can, sensitize employers and employees with respect to their rights under the legislation. I'm going to take 2 more questions. Then I'll run through a few scenarios and questions to ensure everybody, got a good grasp of the presentation, and then we'll wrap up because I'm sure other persons have other meetings and stuff to attend. Ms. Pitt, you have another question? Go ahead.
Sorry, I misimpressed. I misimpressed you. I'm sorry.
Oh, okay, no problem. Mr. Hunt.
Yes, thank you, Mr. Jones. I just want to make a clarification on a question one of my fellow attendees asked in relation to double time being called out. I think she was asking about if her off day was on Wednesday and she was told on Tuesday to come out, she would be paid double time. She should be paid double time. I just want to make a clarification based on your answer. So if an employee on a roster, let's say, is off of Wednesday and I don't know, Saturday or Sunday, for example, and something happens at the company, well, in the COVID times, for example, let's take COVID, for example, where there's not enough coverage on the Wednesday if that person is off, and the employer within reasonable time, let's use 48 hours, which is normally used maybe in the collective agreements where that exists. Are you saying then that that person still has to be paid double time, even if the employer was to say, well, look, can I then arrange to have Thursday off or maybe Friday off instead of the Wednesday because I need the coverage on the Wednesday? I don't know if I misunderstood what she was asking, but for me, I kind of got the impression that if your roster said you're off the Wednesday and the employer gave you reasonable time or outlined the situation and says, well, Wednesday is no longer your off day, or let it change your off day to another day, that you still should be paid for the Wednesday, but you should be paid double.
That is 2 different, if I'm understanding you correctly, that's 2 different scenarios where you're looking to change or exchange, for better term, an off day from one time to another. But regardless of how many times you exchange that off day, if a person is then asked to work on the off day, then they're paid. So that's working on the off day and how you are paid if you're calling on your off day, versus what I'm getting from you is the employer making an arrangement beforehand where they can switch around things in terms of giving a different off day. So giving a different off day does not change the fact that so let's say my off day was Wednesday, you contacted me on Sunday and asked me because of structuring and fixing up your business as a result of COVID that you want my off day to be Friday, then yes, you have effectively changed my off day. However, if when Thursday comes and you call me and I work on Friday, then I still work on my off day, so you still have to pay me double for. I'm not. That's not my query. If you're called to work on your off day,
I mean, that's fair. You get paid double time. I just want it to be.
Right, that was your question.
Yeah. Cool.
Okay, good. All right, so we'll go through a few scenarios and questions quickly so we can wrap up and let you guys have some lunch and stuff. So I'll share my screen for a minute. All right, so we have a quick scenario here. And anyone can jump in at any point. Actually, I'll do the scenario last. Let's do some true or false questions, and then we'll jump into the scenarios after. All right, so the first question here is, a person cannot be dismissed after one incident or one breach. True or false? First person to answer, raise a hand. Okay, who's this? Ms. Brathwaite? Okay, let's try Ms. Smart. Ms. Smart.
A person cannot.
Person cannot be dismissed after one breach.
True.
Is that true?
True.
I'm not sure if I'm in agreement. What if that breach was gross misconduct?
Yes, that is. Yeah, that's why I had to read it over. That is true.
Okay. All right, good. So, I mean that one. You lost, but you learned.
All right.
A warning letter from 2 years prior can be used in the termination of an employee. Any takers? Ms. Laville?
True.
A warning letter from 2 years prior can
No,
be
sorry. No, it can't be. Because then you come back into that year, you have to start again. Sorry.
It's been expunged. All right, that's correct. But I still won because you messed up the first time. All right. Third question. An employee can be invited to a meeting or terminated verbally. You can be invited to a meeting or you can be terminated verbally. Who's going to take a shot at this? Ms. Scott.
Hello.
Hi.
No, everything should be written.
Correct. Very good, Ms. Scott. So that's 2-1. I'm 2, y'all are 1. An employee or his attorney can call and say to the employer that they are appealing his termination. Ms. Cullimore.
False.
Why is that false?
Has to be in writing.
Very good.
By your employee.
Very good. So that's 2 to y'all, 2 to me. An employer can refuse an employee representation at a disciplinary hearing. Mr. Prescott.
I would say that is, let me see, employer can refuse. I would say that is not true.
Not true.
Pause for a reason. I would say that's not true.
That is correct. It is false. An employee must be.
And before you go any further, let me ask on that question, because it can my ask now, because it's something that is faced at times. An employee turns up with a lawyer as their representative. That's why it pause.
Right. Now the legislation speaks to a representative and it outlines what that representative may be. Friend, another colleague and stuff. However, attorneys do turn up, but how can we then say that an attorney is not a friend? But that is a contentious point in the legislation. But what I would say to you, if you're an employer, regardless of if that person turns up as an attorney or not, as I would have explained to Mr. Young during the presentation, you do not let that person bully and take over your meeting. You're still in charge of it.
So because I have a policy that says, if I invite you to a meeting, you can't really bring an attorney It is when we get the discipline. So that's why it was discipline differentiating between meeting and the disciplinary meeting.
Here. Okay.
Yeah.
Because and we remember we went through that with the meeting. If you have the meeting, you're within your right as an employer to have a meeting with a staff member. Is that the disciplinary hearing?
Exactly.
You're speaking with respect to the attorney. So that's clear. That's fine. All right. So treat it all to me. And then a disciplinary hearing is not necessary for issuing a warning letter. Mr. Boyce. Mr. Boyce? Okay, let's try Miss Lovell. Miss Lovell, a disciplinary hearing is not necessary for issuing a warning letter. True or false?
Well, from what I can remember you saying, it must be set out in written.
So is the disciplinary hearing necessary for the warning letter?
I know the answer to that one.
Let's see if someone else can help you. Mr. Prescott.
Yes. No, it's not necessary. So you can have the disciplinary hearing, but you don't have to issue the warning letter. After you investigate and find the facts, you may not have to issue the warning letter.
Okay, so I see the angle that you're coming from, Mr. Prescott. The actual answer that I wanted, though, was that is false, because to issue that warning letter, you need to have a disciplinary hearing. Because remember, all forms of discipline, you need to have that disciplinary hearing. But I understand the angle that you're coming from. But I'll take it as 3 to y'all, 3 to me. So one scenario now that I'll read to you, and then you guys can just throw some suggestions, answers, and beliefs on it. Mark, who was employed for 2 years, was terminated for repeatedly making mistakes in their reports, which made the company look incompetent. He had received 2 prior warnings about this, but still there was no improvement. On the day in question, the employer was so upset and frustrated that he said to Mark, "You are fired. You are fired. Leave my business and do not ever come back, or I will call the police." Is this termination fair or unfair? And give some reasons for your answers. Who's going to take a stab at this? Ms. Smart.
Hi, I believe that it's unfair termination because they did not follow the protocols in terms of the disciplinary hearings. They did not follow that protocol, so he just fired him, and it was not let's call it gross misconduct.
Okay, very good answer, Mr. Prescott.
Yes, it is unfair dismissal. Even though the Mark would have had 2 warnings, the employer had the right to write to Mark, give him the 7 days, invite him to a meeting, invite his representative, and then take the action after he would have done all of that. But to just fire him on the spot, for me, that is unfair dismissal.
Very good. Thanks, Mr. Prescott. Mr. Masco?
Hi. My thinking is that, well, the mistakes that the guy Mark is making could be detrimental to the feasibility of the company. And in that instance, then the employer could use the modified rules. I wouldn't have told Mark to get up and leave one time, but you could have used the modified rules and dismiss him on the spot.
Okay, so you're looking at the reasoning for determination as gross misconduct. That's what you're saying.
Yeah, because like, for example, if the mistakes on his reports causes the company to lose clients, to lose money, to not get new clients, I mean, the effects of his conduct is detrimental to the business. So to me, I wouldn't say that it is outright unfair dismissal. I'm saying that the employer can make a case to use the modified rules.
Okay, so I can agree with you that the employer can make a case to use the modified rules. However, just going based on this scenario, we went a little further, but however, going based on this scenario, even if the employer were looking to use the modified rules for gross misconduct, then he would still need to, at some point in time, issue mark with the,
Correct.
Stating.
Correct. So I wouldn't have said get up and go now. I would have gotten the documentation for him to get up and go, but not at that instance.
Okay, I take your point. All right. Well, based on the discussions that we had and your answers, true or false, even though we tied 3 and 3, and your response to the scenario, I think that everyone on the call pretty much has a pretty good idea and grasp of the 4th and 5th schedule as presented this morning. If at any point in time, anyone believes that they're still unclear, they can still reach out, to the Labor Department, and we can assist you along the way. But it seems, like I said, that you guys have grasped what I would have put forward this morning. And I hope you enjoyed the presentation and continue to have a good day. I will put up some contact information for persons who want to, take a quick copy down of that information if they want to reach out to me or the Labor Department. So thank you for being a very attentive group, and you would have raised some questions that would have challenged myself and obviously some of the other participants. So once again, thank you for joining us, and feel free to sign up for our next sessions, which will be on Thursday, the 10th of March at 9 a.m., starting with Holiday with Pay Act, and then at 10:40, the employment leave. So at this point in time, like I said, I'll just leave the information out for you guys to copy it down. And as soon as you're done, you can either sign out of the session, if not, after 2 or 3 minutes, then I'll get the session closed. So take care and have a good day.
We can dream because there is where it all begins, with a step, knowing we can do it. See the light. It's time to realize our potential to grow, to be whatever we dream. Focus on our goals, to be the winners with science and technology. Together we can go far. Pride and industry, that's our motto. So getting qualified, we can go far.